Let's go to Teresa in Pensacola. Hey, Teresa.
Hello, good morning.
Good morning.
I have a question.
You go right ahead.
Okay. I'm a renter, and my landlord has passed away.
Mm-hmm.
And now the property that I'm in was listed into a trust.
Mm-hmm.
Okay. And I guess the remaining family members, I guess, are grandchildren.
Yeah,
That they
so
had listed in the trust?
you'll be dealing with the successor trustee of the trust. So if the owner of the property created a trust, he would name a successor trustee to him or herself to now take over the property, and that's the person you'll be dealing with.
Okay. Now, if one, now Shirley passed away after Bruce did, and like I said, there was family on both sides in which the original trust was made out to.
Mm-hmm.
Now, now they're finally getting answers, I guess. Well, I'm getting answers on who my rent check is to be made out to.
The property owned by the trust will be made out to the trust.
Would it be made out to, according to the tax records, it's still owned by Bruce and Shirley? Now I'm asked to make it out to Shirley's trust. Does that sound weird?
No, I think an attorney should look on the county records for you to verify how the property's titled. It could you could also check the probate records in the county where the deceased died.
Uh-huh.
So if you told me the person had a trust, but the
Right.
property would have had to been titled to the name of the trust.
Right, which would be Bruce and Shirley. Now I'm being, okay, and then
Well,
Bruce passed away.
Yeah.
Okay.
Yeah, so now if it was just jointly held property between husband and wife and not in a trust, then the will of the deceased would have to go through probate, and in the interim, the check would be made payable to the estate of the last to die.
Oh, so it goes into an estate.
Well, that's what I'm thinking. But I would have an attorney look in the county records to verify of how the property was owned.
Okay, because according to the tax records and everything, it's still under Bruce and Shirley. But they're asking, I'm being
And
asked
Shirley was
to
the
make
last
my
to
rent
die?
checks to Shirley.
Well, Shirley was the last to die.
Correct?
So it would be, Shirley would have been the owner. But Shirley's deceased, so the check really, I'm thinking, should be made payable to the estate of Shirley.
Estate of Shirley, not the Shirley Trust.
Well, it would only go to the Shirley Trust if the property was in the trust. Ask the person, tell the person you talk to an attorney, which you have now, actually.
Well,
hold on.
The attorney won't talk to me.
You're talking to an attorney right now, though.
Well, all I did
okay.
is
Can you just
I received a
listen?
letter.
Can you listen to me? Can I finish my sentence?
Oh, sure. I'm sorry.
That's okay. So tell them you've talked to an attorney, which you have. You've talked to me. And the attorney wanted to know if there was going to be a probate estate opened for Shirley. And if the property was in Shirley's name, it was suggested that the check should be made payable to the estate of Shirley.
Okay.
And see how far that conversation, how far you get with that conversation. Because if there's a reason not to do that, they should explain it to you.
Yeah, but
I think any attorney you talk to would tell you if the real estate is in Shirley's name because she was the last one living, and the property was jointly held between Bruce and Shirley. Now it's all Shirley's, and if she died, now the property's in a deceased person's name, and the check should be made payable to the estate of Shirley.
Now, what happens if that attorney won't talk to me?
Well, you can hire your own attorney to look on the county records themselves and see if they come up with the same answer. And you could also just write a check made payable to have the personal representative. Who's calling you? Somebody from Shirley's estate? Who's actually who's telling you to do the check to Shirley?
An attorney.
Oh, well, that attorney's talking to you. Have him send you that in writing. Tell him I need a written letter from you telling me how to address the check. Don't do things verbally. Take all actions on base something in writing.
Well, he sent me a letter to send the money to the Shirley Trust. But how do I know that's legit? Because I don't want another family member saying, I want my rent money.
Well, okay, so I would have another attorney look at the public records, or maybe correspond with the attorney to verify it was in the trust if the county records are showing otherwise.
You look at public records?
I would have an attorney look at the public records for you and or call the attorney to verify that's the way it should be after they look at the county records.
Okay.
All right. Well,
Thank you.
Hope that helps. Thanks.
Mm-hmm.
Let's go to Dan in St. Pete.
Good morning.
Hey, Dan.
Yeah, Joe, my will is 7 years old with power of attorney and healthcare surrogate and all that. Is that still legal? I mean, should it...
Do you have just a will, or do you have a trust too?
No trust, just a will.
Do you own a home?
Yes.
Is it a single-family home or a manufactured home?
Single.
And do you want your home to go through a probate proceeding?
Well, no, I do not.
All right. So first of all, you might have everything reviewed and discuss the possibility of doing a trust. If you decided to keep a will, then your will is probably fine, and you would not have to renew the will unless you had changes. But power of attorneys, in my opinion, should be updated about every 3 or 4 years.
Okay. All right, I was just concerned because I can recall, and please correct me if I'm wrong, but I thought you stated there were some changes in power of attorney about 3 to 5 years ago.
Yeah, that's what I'm saying. Power of attorney should be updated.
Oh, okay, so it should be updated.
So if I were you, I would go into an attorney. Now, we don't charge anything to review documents. We have a flat fee for a will as a power of attorney is like $125. So you could get your power of attorney, you could get your will reviewed, and you can have a trust discussion. And actually, our first meeting doesn't cost anything if you just want to talk. You could go back to, if you're happy with the attorney that did the will to begin with, you go back to that attorney and discuss the new power of attorney and what a trust would benefit you, and have that discussion with your existing attorney.
Okay. All righty. All right, well, thank you for your time and your expertise.
All right, thank you.
Bye-bye.